Thank you, Mr. Chairman. Welcome again to our committee. I got home last night about 8 o'clock. The first thing I heard was my wife's opinion that you did very good in your opening statement.
Thank you.
She didn't have anything to say about my statement. Also, besides the fact that we might have some votes on the United States Senate, just so that you know I'm not being rude to you, I may have to go across the hall to Finance Committee on some issues with tariffs and down to the Agriculture Committee for some issues on rural health care. Do you believe, well, let me ask it this way. Do the First Amendment free speech protections apply equally to conservative and liberal protesters?
Yes, Senator.
Okay. Do you believe the individual right to keep and bear arms is a fundamental right?
Senator, the Supreme Court has established that the individual right to keep and bear arms is a fundamental right.
Could you tell me how you might go about deciding what a fundamental right is under the Constitution?
Well, Senator, I don't know that I can tell you that in the abstract in the sort of way that you may have posed the question. There is precedent in the Supreme Court related to various rights that the court has recognized as fundamental. The court has some precedents about the standards for determining whether or not something is fundamental. The court has said that the 14th Amendment substantive due process clause does support some fundamental rights, but only things that are implicit in the ordered concept of liberty or deeply rooted in the history and traditions of this country. They're the kinds of rights that relate to personal individual autonomy, and they've recognized a few things in that category, and that's the tradition of the court for determining whether something is fundamental in that way.
Okay. On another subject, kind of personal to me over a long period of time and about half of this committee, but it's a controversial issue even within this committee. I favor allowing Supreme Court hearings to be televised. What's your view on this? How would you feel about cameras in the courtroom, which about 40 or 45 of our states allow?
Well, Senator, I would want to discuss with the other justices their views and understand all of the various potential issues related to cameras in the courtroom before I took a position on it.
I think that's a fair answer at this point. I'm going to ask you about a bill that I got passed a long, long time ago. And it's something that at some level of courts, sometime the district court, sometime at the circuit court, and even once or twice at the Supreme Court, these courts tend to do damage to a bill called the False Claims Act. This bill has brought $70 billion of fraudulently taken money back into the federal treasury since it's been passed. And courts have weakened it, and then Senator Leahy and I usually find ourselves having to pass legislation to say to the courts, you got it wrong. In fact, there's a very controversial bill right now before the United States Senate on that very subject. It's fought fraud in the Department of Defense, healthcare industry, the pharmaceutical industry. $70 billion is pretty important. So when you if you're approved to be on the Supreme Court and the issue of false claims comes up, I hope you think of Chuck Grassley. It's one of the, well, and Leahy. Okay. The False Claims Act is one of the best tools that we have to fight against government fraud and to recover taxpayers' money. I've worked for decades to protect whistleblowers who shine a light on fraud, waste, and abuse in the government. So I'd like to ask you a couple questions. And I'm going to start with a former Attorney General, unnamed, once suggested that Ketanji's suits were, in his words, patently unconstitutional, and another word he used was dangerous. He argued that it violated the Appointments Clause. So, understanding that you may get a case before you on the False Claims Act, but maybe this Appointment Clause is sound enough, you could answer, do Ketanji's suits violate the Appointments Clause?
So, Senator, I am not familiar with that
Could you answer,
representation.
Could you answer in writing then?
Well, I'd be happy to do whatever. I'm just trying to assess.
I'm sorry, I shouldn't have interrupted you.
No, that's all right. Sorry. I am trying to, I'm not familiar with the quotation or what the attorney may have said about them. I know that the Supreme Court has considered various Ketanji actions and has issued opinions in the area and has not, at least to date, found them to be unconstitutional. But I don't know if that issue has been squarely presented to the court, and I would be loath to comment on it, just because if it's being litigated, it's something I wouldn't be able to address.
Let me, on the same subject, also, this former Attorney General also argued that Ketanji's suits also violate a broader separation of power principles. Can you tell me whether you think the president's constitutional powers are violated when private citizens are allowed to sue in the name of the United States, and that's what Ketanji suits are all about, private citizens going to court?
Well, Senator, it is an important concern. There are statutes that do allow for the kinds of lawsuits that you are articulating. I am not aware of impediments to those, but again, this is the kind of thing that may be litigated, and I would have to look, as I do, consistent with my methodology, at any arguments that are raised about the constitutionality or lawfulness of those actions.
Remember, in about all of these suits that involve the courts in making interpretations of the False Claims Act, most of them are brought by whistleblowers. And remember, the government would not even know about these fraudulent use of taxpayers without whistleblowers coming forth. And they ought to be given some credit for wanting the government to do what the laws say it ought to do and spend the money the way that the Constitution or that the Congress implies that that money be spent. I want to move on. At an event at the University of Chicago School of Law in 2020, you quoted Martin Luther King Jr., who dreamt of a time when, quote, the sons of former slaves and the sons of former slave owners would be able to sit down together at the table of brotherhood, end of quote. You talked about how quickly things in the country then changed, including the civil rights laws, over the next few years because of the civil rights movement. You added that, quote, less than a decade after Dr. King's words, that was the world that you inhabited. Dr. King hoped for a country where we would all be judged by the content of our character rather than our race. Do these quotes still reflect your views on this very important topic today?
Yes, Senator. In that speech, I talked about my background, my upbringing, the fact that my parents, when they were growing up in Miami, Florida, attended and had to attend racially segregated schools because by law, when they were young, white children and black children were not allowed to go to school together. And my reality, when I was born in 1970 and went to school in Miami, Florida, was completely different. I went to a diverse public junior high school, elementary school. And the fact that we had come that far was, to me, a testament to the hope and the promise of this country, the greatness of America, that in one generation, we could go from racially segregated schools in Florida to have me sitting here as the first Floridian ever to be nominated to the Supreme Court of the United States. So yes, Senator, that is my belief.
And I think that it's good that the country had an opportunity to hear what you just told us about your experience. I'm going to go to something that the chairman brought up, and I've written down the three steps you go through. No, another question, but also one that he brought up on court packing and your opinion. I heard what you said, and you said it should be a policy question, but I want to go to something in 2013 during your hearing to be a district court judge. Senator Coburn asked you whether you believed in the theory that the Constitution is a living document whose meaning evolves over time. You said no. In 2021, however, during your circuit court nomination hearing, you declined to answer the same question when asked why the answer to your question of 2013 and not in 2021 in written questions, you noted that you weren't a sitting judge. So please explain to me or describe for us the difference between ethical rules for sitting judges versus judicial nominees who are not already judges.
Senator, I don't know that there are ethical rules that are different. What I'll say is, with respect to my approach to judging, there is not a label, I think, that fits what it is that I do and how I've approached my role. As I mentioned to the chairman, I'm very acutely aware of the limitations on the exercise of my judicial power. And those limitations come in the form of adherence to the text. Assuming you even get to that stage of the process, that you have subject matter jurisdiction, you can reach the merits, then you are looking at the text, and I do not believe that there is a living constitution in the sense that it's changing and it's infused with my own policy perspective or the policy perspective of the day. Instead, the Supreme Court has made clear that when you're interpreting the Constitution, you're looking at the text at the time of the founding and what the meaning was then as a constraint on my own authority. And so I apply that constraint. I look at the text to determine what it meant to those who drafted it.
On this same subject, I want to point out a difference between you and a couple people that have sat on the Supreme Court. Justice Breyer said that a structural alteration of the Supreme Court motivated by a perception of political influence can only feed the perception of political influence, that's my parenthetical, further eroding that trust. Justice Ginsburg also cited court packing as being, quote unquote, a bad idea. Court packing is creating new seats for political purposes for a president to appoint more judges. Do you agree with Justice Breyer and Justice Ginsburg that court packing is a bad idea? Before you respond, I'd like to say that you say this question should be left to Congress as a policy issue. I'd reiterate that sitting Supreme Court justices have spoken on that matter, so I don't think it'd be inappropriate for you to do if other people sitting there have said that it's a bad idea.
Well, respectfully, Senator, other nominees to the Supreme Court have responded as I will, which is that it is a policy question for Congress. And I am particularly mindful of not speaking to policy issues because I am so committed to staying in my lane of the system, because I'm just not willing to speak to issues that are properly in the province of this body.
Okay. Then I would interpret your answer, and you don't have to respond to this, but I think you're saying Breyer and Ginsburg should not have stated their views on that issue. During his opening statement yesterday, one member of this committee suggested that the Supreme Court has been bought by dark money groups. Do you agree that the Supreme Court has been bought by dark money groups?
Senator, I don't have any reason to believe that that's the case. I have only the highest esteem for the members of the Supreme Court, whom I hope to be able to join if I'm confirmed, and for all of the members of the judiciary.
Thank you for that answer. I'm going to go to international law. During an ABA panel on international law last year, Justice Breyer said that as a federal judge, quote, "You can't do your job properly," end of quote, without considering international law and, quote again, in some cases, and it's a growing number, end of quote, and I assume a growing number of opportunities to use international law. In 2018 op-ed, Justice Breyer said that, quote, "The best way to preserve American values may well be to take account of what happens abroad," end of quote. Under what circumstances is it appropriate to consider international law when interpreting our Constitution?
Thank you, Senator. I have nothing but the highest esteem and respect for my former boss, who I've spent the better part of the past couple decades calling my justice, having clerked for him. But I do think that the use of international law is very limited in our scheme and in our judging. There are certain cases in which it is relied upon where Congress directs or where the standards are such. The case involves a treaty, for example, and you have to interpret international law in order to be able to address it. But there are very, very few cases, I think, in which international law plays any role, and certainly not in interpreting the Constitution.
I think you probably have answered my next two questions, but if you say you have nothing to add, I would still want to ask the questions. Do you think it's appropriate to look to international law when interpreting enumerated and unenumerated constitutional rights?
No, Senator.
Which specific, again, I think you've answered this, but I want to ask it anyway. Which specific constitutional clauses or rights has the Supreme Court held that can be interpreted by looking to international law?
I'm not aware of any that are properly illuminated by reference to international law.
Yeah. Now I want to go to a question that Senator Durbin asked. I'll probably go a little more, but I remember when this is about your judicial philosophy, and you made 3 points, 3 steps you take to go through a case and apply the law, and you say your methodology is limited power and stay within your lane. I'd like to ask you, well, you've served on the district court for several years and spent 8 months on the DC circuit. During yesterday's opening statement, we heard a lot about the importance of judicial philosophy. In your own words, you've described that, so you don't have to go through that again with me. But if Congress writes a law that does not explicitly allow private parties to sue, do you believe that the federal courts have the authority to create implied causes of action? And I'd like to have you elaborate if you say yes to that.
I would say that as a general matter, no, Senator. I mean, our obligation as judges is not to create policy. And if Congress has enacted a statute that establishes a cause of action or restricts causes of action, then as a general matter, I don't think that courts can impose one. Now, you know, I'm saying generally because there may be circumstances that I'm not thinking of. I know that the Supreme Court has, in very narrow circumstances at times, discussed implied causes of action. But I think the charge of the judge is to impose the law as written.
There's 115 justices that serve before you if you are approved by the Senate. Is there any of them now or in the past that has a judicial philosophy that most closely resembles your own?
You know, I haven't studied the judicial philosophies of all of the prior justices. I will say that I come to this position, to this moment, as a judge who comes from practice, that I was a trial judge, and my methodology has developed in that context. I don't know how many other justices, other than Justice Sotomayor, have that same perspective, but it informs me with respect to what I understand to be my proper judicial role.
What aspect of your record as a judge do you believe have been the most important for the good of the country?
Well, I think that all of my record is important to some degree because I think it clearly demonstrates that I'm an independent jurist, that I am ruling in every case consistent with the methodology that I've described, that I'm impartial. I don't think that anyone can look at my record and say that it is pointing in one direction or another, that it is supporting one viewpoint or another. I am doing the work and have done the work for the past 10 years that judges do to rule impartially and to stay within the boundaries of our proper judicial role.
Let's go to immigration. Congress gave the Attorney General, quote, unquote, sole and unreviewable discretion to decide whether expedited removal would apply to, quote, an alien who has not been paroled or admitted to the United States. You decided a case called Make the Road, New York, where you seem to agree that Congress gave the Department of Homeland Security sole and unreviewable discretion to decide which illegal immigrants would be subject to expedited removal. But you still went on to review the department's decision. In fact, you issued a nationwide injunction blocking Department of Homeland Security from removing illegal immigrants who had been in the country for less than 2 years. In that hearing, you told us that if the text was clear, that ended the question. The law specifically says that Homeland Security, not the courts, was responsible for making the decision. Could you please explain why you believed a federal court could review something Congress called unreviewable?
Thank you, Senator, for allowing me to address that opinion and my analysis with respect to it. As you said, Make the Road was a case involving a challenge to expedited removal, which was a way in which Congress had given the authority to to the Department of Homeland Security to make a decision about how to deport people who are non-citizens. Prior to the challenge that I heard, the Department of Homeland Security, since it received that authority several decades ago, had decided that people who are in this country for up to 14 days and are found within 100 miles of the border are subject to expedited removal. The challenge that I heard involved the department's sudden shift to a determination that expedited removal would be applied to anyone who was found anywhere in the country and who had been here up to 2 years. Importantly, the challenge was not about the actual determination. The challenge was about the procedures that the agency undertook to make that determination. And so the statute said, as you rightly pointed out, that the agency had sole and unreviewable discretion to decide. And in interpreting that, I took into account the language of that statute and the language of another statute that Congress has enacted to direct agencies with respect to the manner in which they exercise their discretion. So I said, and I believed, that sole meant that the Department of Homeland Security was the only agency who got to make this determination as to how many months a person should be in the United States. And unreviewable meant it was final. Once the agency decided, then there was no ability to review substantively their determination. And I should say that, importantly, the statute that Congress enacted gave the agency the discretion to make this determination between 0 and 24 months. There is a limit in the statute. It says Department of Homeland Security, you get to decide where between 0 and 24 months a person who's been in this country can be subject to expedited removal. So I read the statute. DHS gets the sole ability to make that decision. DHS makes that decision and it's final. What wasn't clear to me based on that language was whether Congress intended to preclude its procedural requirements for the exercise of agency discretion. And in the DC Circuit, there was precedent that indicated that even when Congress gives a great deal of discretion to an agency, procedural requirements may still apply. It is presumptive that the APA applies, meaning that an agency can't act arbitrarily and capriciously when it undertakes to exercise discretion. It has to do certain things in order to make the determination that Congress has given it. I looked at those statutes. Oh, I'm sorry.
No.
I looked at those statutes and I considered the canons of construction that say that statutes should be read harmoniously, that as a court you're supposed to understand that Congress has directed, sometimes in more than one statute, what is supposed to happen. And so I read them together to mean that the court could still do what it almost always does in a case involving a challenge to the manner in which an agency makes its decision. And in fact, I thought, as I say in my opinion, that Congress intended for the APA to imply, because it had not excluded it, which it had done expressly in other parts of the INA. It had not excluded it here, and it made sense to require the agency to use its expertise. If Congress wanted the agency to act arbitrarily in picking a number, Congress could have done that. Congress said you can do it up to 24 months. It could have randomly picked a number. But it was giving it to the agency, I thought, and reasoned, precisely because it wanted the agency to use its expertise, to do its research, and to figure out what amount of time is sufficient. And so it was important, I thought, to lay that out in the statute, and I determined that both of those statutory directives of Congress should apply.